Once you reach a settlement in mediation, you are almost home free, so to speak. The mediator will draft a term sheet for you. The term sheets will embody everything that you and your spouse have agreed to do, what you've agreed not to do, and those terms then become a binding agreement between the two of you. You can either then go off to your own attorneys and prepare full-blown marital settlement agreements, or you can have a simple uncontested divorce and use the term sheet as your guidepost, and then your process is complete. Does your mediated agreement hold up in court, or is it just the structure for a settlement? And the answer to that is it depends. And this is a decision that you and your spouse have to make at the onset of mediation, or at least before you conclude mediation. So a mediated term sheet can be binding or non-binding. Some parties say, well, why would I go through this whole process if my spouse can back out of it? Well, that might be the only way you get your spouse to mediation to begin with. It becomes a strategic decision that you make at the onset of mediation. And so if it's a binding term sheet, yes, it is something that a judge will uphold in court, so long as you have the right language in here saying everybody understood that it was binding, that you're waiving your right to a trial, and all of that legal protective language. As long as that's in your agreement, a court will uphold your term sheet. Partial mediation, is that a thing? Sure, it can be. Perhaps you've reached agreement, or you want to reach agreement in mediation on all things related to your children, but the financial component of your divorce might feel like it's something that's either too complex or you're at a stalemate with your spouse. So you want to mediate a partial resolution of your case, and you're well within your rights to do that so long as you and your spouse agree to it. We can absolutely do a partial settlement. Some people resolve the financial issues in mediation and say, you know what, we're going to have a judge call the custody issues. You can absolutely have that autonomy. In the state of New Jersey, most people that settle their case through some form of alternative dispute resolution, historically and statistically speaking, spend less time in court post-divorce. Why? Because this is a resolution that you crafted with your spouse, and other than an enforcement action, the need to rework the agreement occurs less often because it's an agreement that you reached together rather than a position that a judge forced upon you. So mediated settlements tend to have fewer post-judgment issues, unlike a case that's tried to completion. Mediation allows you and your soon-to-be former spouse to sit in the driver's seat. You can decide whether mediation is binding or non-binding. You can decide whether you want to mediate all the issues in your divorce or some of the issues in your divorce. And a mediated settlement agreement, a term sheet, a marital settlement agreement, whatever naming convention we give this final document, can absolutely be a binding agreement that stands the test of time post-divorce and governs how you and your former spouse interact as it relates to your children and resolves how you divide all of the financial issues in your case. If you have any questions about mediation, feel free to reach out to our office and we can walk you through the process.